Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, evidence overview, relevance, reliability, and the trial record. Let's begin. Evidence is the law of what the fact finder may hear and how the lawyer gets it there. On the bar exam, every evidence problem starts with a simple sequence. Identify the purpose for which the evidence is offered, decide whether it is relevant, ask whether a specific exclusionary rule applies, and then determine whether an exception, exemption, or a limiting instruction saves it. Relevance opens the door, but reliability, fairness, policy, and constitutional rules decide whether the evidence stays in. The federal rules of evidence govern the MBE. California essays use the California Evidence Code, and California often reaches the same result with different labels, burdens, or exceptions. Do not write generic evidence law on a California essay if the facts cue California. Name the California Evidence Code rule when possible, especially for hearsay, privileges, character evidence in civil cases, and Prop 8 in criminal cases. Relevance. Evidence is relevant if it has any tendency to make a fact of consequence more or less probable. Relevant evidence is admissible unless excluded by another rule. The threshold is low. Discretionary exclusion. Under FRE 403, the court may exclude relevant evidence if its probative value is substantially outweighed by unfair prejudice, confusion, misleading the jury, undue delay, wasting time, or cumulative proof. California Evidence Code Section 352 is similar and lets the court exclude when probative value is substantially outweighed by undue prejudice, confusion, or time consumption. Conditional relevance. When relevance depends on a preliminary fact, the judge admits the evidence if a reasonable jury could find that fact by a preponderance. Authentication works this way. The proponent need only produce evidence sufficient to support a finding that the item is what the proponent claims. Purpose. Ask why the evidence is offered. The same fact may be inadmissible for propensity, but admissible for motive, notice, ownership, intent, identity, impeachment, or effect on the listener. Relevance. Tie the fact to an element, defense, witness credibility point, or damages issue. If the fact does not move a legally significant needle, it is irrelevant. Exclusion. Consider unfair prejudice, character rules, subsequent remedial measures, settlements, plea discussions, liability insurance, privileges, hearsay, authentication, best evidence, opinion limits, and constitutional objections. Limiting instruction. If evidence is admissible for one purpose but not another, the court should restrict the evidence to its proper purpose on request. Preservation. Objections must be timely and specific unless the ground is apparent. A motion to strike is needed when the objectionable material comes in before counsel can object. Prop 8. In California criminal cases, relevant evidence is generally admissible even if a California exclusionary rule would otherwise bar it, unless an exception applies. Prop 8 does not override federal constitutional rules, hearsay law, privilege law, Section 352 balancing, rape shield protections, or rules enacted by a 2/3 legislative vote after Prop 8. Prop 8 is a favorite essay trap. It can make relevant character or impeachment evidence admissible in a criminal case, subject to Section 352. California privileges. California privileges are statutory and strictly governed by the Evidence Code. There is no broad judicial privilege-making power comparable to federal common law in some contexts. If a California privilege applies, Prop 8 does not abrogate it. Preliminary facts. California distinguishes preliminary facts affecting admissibility from facts affecting weight. The judge decides foundational admissibility issues, but where the fact is merely necessary for the jury to evaluate relevance, the jury may decide weight. Do not stop at relevance. Nearly every tested item is relevant. The points come from the exclusion or exception. Unfair prejudice does not mean harmful. It means an improper emotional or irrational basis, or a risk the jury will misuse the evidence. Character, evidence, and habit are different. Habit is a regular response to a specific situation and is admissible to prove conduct in conformity. Character is a general trait and is often restricted. Authentication is not proof beyond dispute. A text message, photo, recording, or business record can be authenticated by circumstantial evidence. Best evidence is narrow. It applies when a party seeks to prove the contents of a writing, recording, or photograph, not whenever a document exists. Judicial notice proves indisputable facts, but in criminal cases the jury must be told it may or may not accept a judicially noticed fact under the federal rule. California has its own mandatory and permissive notice rules. MBE questions often give you 4 plausible objections. Build a checklist. Relevance, 403 or 352. Character, hearsay, privilege, authentication, and opinion. The correct answer usually turns on the precise purpose. If a statement is offered to show notice, effect on the listener, verbal act, or circumstantial state of mind, it is not hearsay. If a prior act is offered to show motive, intent, plan, identity, or absence of mistake, it may be non-propensity evidence even though it looks like character. California essays reward structure. Right. The evidence is relevant because, however, the objection is, under the CEC, in a California criminal case Prop may 8 apply. Nevertheless, Section 352, hearsay, privilege, or constitutional limits remain. Then conclude. Note, evidence answers are strongest when they use short admissibility rulings, admissible for X but not for Y, with limiting instruction. That is exactly how judges think at trial. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.